Imagine standing on the front porch of a home that has been in your family for 3 generations. You know every creak in the floorboards and every tree in the yard. Then, you receive a formal, sterile notice in the mail declaring that the land beneath your feet is no longer yours. The government wants your property, and they are not asking for permission to take it. They are simply informing you of a finalized decision. This is not a hypothetical nightmare drawn from a dystopian novel, but a harsh legal reality faced by thousands of Americans every single year. This extraordinary and deeply unsettling government power is known as eminent domain. It is the inherent authority of a sovereign entity to seize private land for a broader public purpose, even if the property owner violently objects and refuses to sell. While it sounds like an authoritarian overreach designed to crush individual liberty, this mechanism is deeply embedded in the foundational fabric of American law, serving as a brutal but necessary tool for societal expansion. The framers of the Constitution recognized the terrifying potential of this immense power, but sought to restrain it through the Fifth Amendment. Tucked at the very end of this crucial text is the Takings Clause, which explicitly states that private property shall not be taken for public use without just compensation. It is a delicate, often fraught compromise, balancing the undeniable, practical needs of a rapidly growing nation against the absolute sanctity of individual ownership and personal sanctuary. Historically, demystifying this constitutional mechanism was relatively straightforward, and its application was largely uncontroversial. In the 19th and early 20th centuries, the government primarily wielded this authority to build tangible, highly visible civic infrastructure. If a new transcontinental railroad, an interstate highway, or a federal post office needed to be constructed across a specific geographic route, private land was condemned, the owner was paid, and the general public directly utilized the resulting project. The legal machinery of this process hinges on 2 distinct, mandatory pillars that must be satisfied to legitimize the forced seizure. First, the proposed project must genuinely serve the public. Second, the displaced homeowner must receive fair market value for their loss. However, the judicial interpretation of these 2 seemingly simple, straightforward requirements has triggered some of the most contentious, emotionally charged legal battles in modern American history. The concept of just compensation, for instance, often leaves property owners feeling fundamentally shortchanged and financially devastated. The law dictates that fair market value is what a willing buyer would pay a willing seller on the open market. But in these state-mandated scenarios, the seller is decidedly unwilling. The strict, sterile financial calculation completely ignores the sentimental value of a family legacy, the logistical cost of uprooting an entire life, and the sheer emotional trauma of forced relocation. Even more controversial than the financial payout is the evolving, highly malleable definition of what actually constitutes a valid public use. Over the decades, municipal governments pushed the boundaries, and the courts began to drift away from requiring direct, physical public access, such as a traditional road or a municipal park. The legal definition quietly expanded to encompass the broader, much more ambiguous concept of a general public purpose. This monumental shift was cemented in the mid-20th century when the Supreme Court allowed cities to aggressively clear blighted neighborhoods under the banner of urban renewal. The judicial rationale was that eliminating urban decay served a valid public purpose, even if the seized land was eventually handed over to private commercial developers to build office buildings. This established a perilous legal precedent, actively blurring the once clear line between civic necessity and private corporate profit. Suddenly, everyday homeowners were no longer just making way for essential schools and vital bridges. They were increasingly vulnerable to having their land seized simply because a private corporation convinced local officials that a new luxury shopping mall or a high-end condominium complex would generate significantly more tax revenue than the existing, older homes. The fundamental constitutional right to property was now being routinely weighed against municipal ledgers and speculative economic forecasts. The absolute breaking point for this escalating legal tension arrived in 2005 with the landmark, highly publicized Supreme Court case Kalo v. City of New London. Suzette Kalo had extensively, lovingly restored a little pink house in a working-class neighborhood in Connecticut. The local government decided to condemn her property, along with the homes of several defiant neighbors, not to build a public road, but to clear massive space for a comprehensive private redevelopment plan anchored by a sprawling Pfizer pharmaceutical research facility. The city forcefully argued that the anticipated economic boom, including thousands of new jobs and vastly increased property tax revenue, perfectly satisfied the constitutional requirement for a public use. The homeowners fought back with equal ferocity, arguing that taking property from one private citizen simply to hand it to a wealthier, more powerful private corporation was a blatant, unconstitutional violation of their foundational rights. The legal battle lines were drawn over the very soul and original intent of the Takings Clause. In a deeply divided, highly controversial 5-4 decision, the Supreme Court ultimately sided with the city. The majority ruled that economic development does, in fact, qualify as a valid public use under the Constitution. They chose to defer heavily to the local government's legislative judgment, concluding that the projected economic benefits to the struggling community legally justified the forced, involuntary seizure of private residential homes. The backlash from the bench was immediate, eloquent, and fierce. Justice Sandra Day O'Connor penned a blistering dissent, warning that the ruling effectively deleted the words "for public use" from the United States Constitution. She cautioned that any property could now be legally taken for the benefit of another private party, famously stating that the beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, leaving ordinary homeowners entirely defenseless. The reverberations of that fractured judicial decision sparked absolute bipartisan national outrage. Across the political spectrum, citizens were horrified by the sudden, glaring vulnerability of their own homes and neighborhoods. In direct response, over 40 states swiftly passed new protective legislation or state constitutional amendments designed to strictly limit or outright ban the use of eminent domain for purely private economic development, desperately attempting to close the massive loophole the Supreme Court had just widened. The tragic, bitter irony of the Kelo decision only deepened with the passage of time. The grand, transformative pharmaceutical facility that justified the destruction of an entire neighborhood was never actually built. The private developer failed to secure the necessary financing, and Pfizer eventually abandoned the city altogether. Today, the land where Suzette Kelo's little pink house once proudly stood remains a barren, overgrown, empty lot, serving as a stark, physical monument to the devastating potential of unchecked government overreach. The echoes of that landmark decision still resonate loudly through the modern legal landscape. The fundamental vulnerability exposed by the ruling forced a collective, nationwide reckoning with how easily foundational liberties can be eroded by the seductive promise of economic progress. The inherent tension between aggressive municipal ambition and individual domestic security remains a permanent, highly volatile fixture of modern urban planning. For modern homeowners facing this terrifying reality today, understanding the exact mechanics of a condemnation proceeding is absolutely critical. The process typically begins with a government appraisal and a formal initial financial offer. If the homeowner refuses the offer, the state or municipality files a formal lawsuit to condemn the property, instantly shifting the battleground from the negotiation table directly into the adversarial arena of the courtroom. At this critical judicial juncture, the property owner essentially has two distinct avenues of legal defense. They can attempt to challenge the legality of the taking itself, arguing that the proposed project does not meet the legal threshold for a valid public use, though this remains a notoriously difficult, uphill battle to win. Alternatively, they can fight aggressively over the valuation, presenting independent, expert appraisals to demand a higher, truly representative just compensation. Regardless of the chosen legal strategy, the ultimate burden placed on the ordinary citizen is immense and deeply unfair. They are forced to expend significant, often ruinous financial resources and massive emotional energy simply to defend a home they never had any intention of selling. The legal machinery of property condemnation operates with a cold, relentless bureaucratic efficiency that rarely accounts for the profound, lasting human cost of forced displacement. As national infrastructure rapidly ages and the urgent demand for massive renewable energy projects and climate adaptation measures accelerates, the use of this governmental power will inevitably increase. The expansion of high-speed rail lines, the vast construction of massive solar farms, and the necessary reinforcement of coastal defenses will require the acquisition of immense tracts of private land, setting the stage for the next major generation of constitutional clashes. These impending future conflicts will severely test the boundaries and durability of those state-level protections enacted in the immediate aftermath of the controversies of the early 2000s. Local and federal courts will once again be tasked with the impossible job of weighing the urgent, undeniable collective needs of a changing society against the fierce, localized resistance of individuals who simply want to be left alone on their own land. Ultimately, the power to seize land is widely recognized as a necessary tool for a functioning, evolving society, but it is one fraught with inherent, undeniable danger. The ongoing endless debate surrounding the takings clause serves as a vital, sobering reminder that the rights of property owners are only as secure as the courts and the voting public are willing to demand. The delicate balance between collective national progress and individual domestic sanctuary remains one of the most fragile, hotly contested compromises in the entire American legal system.